Good afternoon, Ms. Mthimkulu.
Good afternoon, DCJ.
Are you ready?
Yes, I am.
All right. You hold a number of academic qualifications.
5 to be exact, DCJ.
Do you want to tell us what those are?
I hold a BA LLB from the University of Cape Town. I higher diploma in tax law. I higher diploma in international tax law from the University of Johannesburg, and an LLM from a university in the United States.
An LLM in intellectual property law, you should mention that.
Yes, DCJ.
All right. When did you obtain these qualifications?
I obtained my BA in 1991, my LLB in 1995, my higher diploma in tax law in 2010, my higher diploma in international tax law in 2011, and my LLM in 2014.
And you, well, the last three you did while you were working, or you were already on the job market.
That is correct, DCJ.
Where did you find the time?
I had to stretch myself, DCJ. In a 24-hour day, I had to do a lot of my work as well as my studying.
All right. So after you did your articles with the Legal Aid Board, you worked for the Road Accident Fund as a claims handler and didn't spend a long time there. You opened your own, you started your own practice.
That is correct, DCJ.
How long did you run your own practice?
I ran my practice for approximately a year
And then went back to the Legal Aid Board.
and went back to the Legal Aid Board.
But you didn't stay long there either. You left and went to the NPA.
That is correct, DCJ.
And from the NPA, you became a magistrate. That was in 2002.
That is correct.
And that's where you've been. You've been working your way up the ranks, I see.
That is
Today.
correct, DCJ.
All right. So you started as a district magistrate, and that was quite a longish spell. For what, 8 years?
I was in the district court for 8 years.
And then became a regional magistrate.
I became a regional magistrate in 2010.
Yeah. But then you went, did you go back to the district court? I'm a bit confused. What happened between 2015 and 2019?
DCJ, my story is, or rather my route is a bit of a unique one. I was appointed a regional magistrate in 2010, and I resigned in 2013 because I was offered an opportunity to go and study in the USA. I got offered a scholarship by the University of New Hampshire School of Law to do an LLM in IP law. And when that offer came about, I approached my regional court president then, as well as the Magistrates Commission, to see if I could be granted sabbatical leave for me to go and study in the US. And I was advised by both my regional court president as well as the Magistrates Commission that if they were to agree to my request, it would set a bad precedent, and they refused the sabbatical leave. I then decided to resign because I thought it was an opportunity of a lifetime and I could not let go of it.
So when you came back, you had to start at the district court?
When I came back, I had to start in the district court again.
But then you found your way back to the regional court?
That is correct, DCJ.
All right. Your first acting stint was in mid-2021.
That is correct. The third term of 2021.
Yes, and you've acted intermittently until December 2022.
I have actually acted up until the 24th of March 2023. That is not indicated in my CV because of the time when I had submitted my application. But I was in the High Court in the first term of this year.
All right. In which division have you acted?
I have acted in the Gauteng division of the High Court as well as in the Limpopo division of the High Court.
Right. And
However, DCJ, in the Limpopo division, I've only acted for a period of 5 weeks.
is that where you've acted in 2023?
That is correct.
I see. And so what is the cumulative, what's the total of your acting stints?
If my calculation is correct, and I am subject to correction, it is about 45 weeks.
45 weeks, all right. Which meets JP Mlambo's standard of 28 weeks. It far surpasses it. Just pulling your leg, JP Mlambo. All right. Have you had an opportunity to pen any judgments during your acting stints? And if so, how many?
I've had the opportunity to pen judgments during my acting stints, and I have penned at least 16 or 17 judgments.
Okay. I see from your CV that you sat both in the criminal and civil courts.
I have sat in both. Well, in Gauteng, I've only sat in the criminal courts. However, when I was approached by the Limpopo division, well, the JP in Limpopo, I was offered an opportunity to sit in the civil court and in motion proceedings.
So your first experience in the civil court has been in 2023, in these 5 weeks you mentioned?
That is correct, DCJ. That's notwithstanding the the other civil work that I've done in both the district court and the regional courts.
Of course.
Yes.
All right. Do you have any reserved judgments in the High Court? Well, both in the High Court and in the regional court?
In the regional court, I do not have any reserved judgments. I do, however, have reserved judgments in the Limpopo division of the High Court because it's not long that I have left.
Those would be new.
Those
were
would
fresh.
be new, yes.
Mhm. Do you have any part heads from the regional court?
I have in the regional court to date about 6 part-head matters. And in all those matters, the accused persons are out on bail.
All right.
In the regional, that's in the regional court. In the Gauteng division of the High Court, that is in Johannesburg, I also have a part-head matter that we started in 2022. And it is one lengthy one. It involves 5 accused persons who are all in custody, and I think they're facing about 62 counts in that matter.
All right.
And it had about 124 witnesses. We've dealt with about 68 of those witnesses.
Yeah, it's one of those monster cases. All right. Okay, I'll leave it at this point for now and hand over to the other commissioners to put questions to you if they have any. AJP?
Thank you, DCJ. Have you ever been in Thohoyandou in your life?
We can't hear you at all.
Have you ever been in Thohoyandou in your life?
I have never been in
You have never
Thohoyandou.
been. You don't even have a clue of where the court is.
I don't even have a clue of where
Still
that
can't
court
hear
is.
you, AJP. I'm
Yo.
sorry. Just turn it around so that you speak directly into it.
Okay, you say you don't even have a clue of where the High Court is and whether you will be, you'll be comfortable with working at Thohoyandou. You don't know.
I don't think it would be a problem, and I'll tell you why, Acting JP. I have worked in a lot of courts. When I was appointed in the regional court, I was appointed a regional magistrate in Klerksdorp. And it wasn't with difficulty that I fitted into that court. So as long as Thohoyandou is in South Africa, I don't think it would be a problem.
Thank you. I have worked with you for quite a short period of time, and also the judges in Limpopo worked with you for quite a short period of time. But all I can say is that I never even had any complaint about you from either
AJP.
from either the practitioners or the sorry about that, from either the practitioners or the colleagues, and I cannot say much further about this.
Thank you, Acting Judge President. I'm one of those people, wherever I go, I try and be collegial to everybody that I work with. So if you had any complaints, I would be surprised. It's not in my nature to ruffle feathers. So I think this is why you haven't had any complaints. Thank you.
I have no further questions, thank you.
Thank you, DCJ. Mr. Mthimkulu, good afternoon.
Good afternoon, Commissioner.
I've asked all the candidates the same question on traditional leadership. It's a very strong institution in the Limpopo province. I understand you may be coming from Gauteng and other places that, well, the last I remember, Gauteng had only 2 traditional leaders. In Limpopo, we have almost 200. So traditional leadership litigation forms a fair amount of the court workload. Have you had any experience in traditional leadership, either as a practitioner? Sorry, you didn't practice. Have you had any experience in traditional leadership as a presiding?
I think having presided in Gauteng largely and having practiced in Gauteng, I haven't had any. However, when I got to Limpopo and I was faced with situations where I had to deliberate or adjudicate on those matters, I've always approached the senior judges just for guidance and also read up on those issues.
Okay, thanks. And then I just want to refer you to a comment made by the Limpopo Law Society at point 28.4, where they say that appointing you will not send a wrong message, though she still needs to learn on other fields of law as she is more experienced in criminal law than other fields of law. And keeping in mind with your lack of experience on traditional leadership matters, how would you comment on that?
I think they have their own opinion of what it is needed of me, and I wouldn't say it's right or wrong. If that's their view, then so be it. But I think I am capable, and I've always said when I am faced with a matter or something in the law that I feel uneasy about, I always consult. I always speak to other judges to find out more about the subject matter. I'm not shy of asking and acquitting myself before I decide on matters. So even if I was faced with a matter wherein I wasn't sure, I would consult and find out or read more about or research more about. As judicial officers, I think nobody can sit here and say, I know it all. So I will ask if it's something that I'm not sure about.
Thank you, DCJ.
Commissioner, AP Pese.
Thank you, DCJ. Good afternoon, Ms. Mthimkulu.
Good afternoon, Commissioner.
Just two questions from my side. What does Kruger versus Kutsi tell us about the proper approach to establishing negligence for purposes of liability in intellectual claims?
Having not done any intellectual claims in a while, I'm not in a position to can answer you. And if I were to try, I would just bluff. So I would have to have a look at it.
Well, the test for establishing negligence for purposes of liability in an intellectual claim, forget about Kruger versus Kutse. What would a plaintiff need to establish before liability on the basis of negligence may ensue?
I'm trying hard to think. I can't think at this point in time.
Thank you.
I'm not sure whether it would be culpa, but I would have to have a look at it, I am afraid.
Thank you. Then the second and last question. When you sit as a member of an appellate court in an appeal against sentence, generally without reference to the Minimum Sentences Act, under what circumstances would an appellate court be justified in interfering with the sentence imposed by the trial court?
If you are of the view that the trial court, or rather that the interest of justice were not served by the trial court in the passing of sentence, and having balanced the personal circumstances of the accused, the offense committed, as well as the interest of society, you feel that there was a misdirection in the passing of sentence.
Thank you.
Thank you,
Thank
AP.
you, DCJ.
Commissioner Nyambi.
Thank you, DCJ. Afternoon, Ms. Mthimkulu.
Good afternoon, Commissioner Nyambi.
So that I don't become unfair when we're doing deliberations in a closed session. Sitting there, you are a candidate that has never been to Thohoyandou. Probably you are applying to go to a place that you don't know. I don't want to have wrong assumption. Maybe if you can explain the reason why you never thought it's necessary for you to understand the place you'll be going to. Is the issue of the division of Thohoyandou. She said she has never been to Thohoyandou. So for me, when doing deliberations, because sitting there is a person who has never been to Thohoyandou, probably if you can share the reason why you have never bothered yourself to understand the place you are going to, so that we are comfortable that you'll stay there. It's not a person that after appointment won't be comfortable because you'll be seeing the place for the first time.
Thank you, Commissioner Nyambi. My not going to Thohoyandou, it was not because I was not interested in going. I think because of work commitments at the Polokwane court, I did not have the opportunity. It had been planned that I would go and visit the place and familiarize myself with the court there. in the week, on the day of the public holiday in March, because I was already closer to Thohoyandou. But on the 21st of March, or in that week, I was seized with presiding over urgent applications, and there was a matter wherein I had to preside over, and that matter took preference, and I could not get away from that matter and had to deal with the matter on the 21st of March 2023. But it had been my wish to go to Thohoyandou. But also in that week, we also had the national shutdown, and we were advised that we should try and not be on the roads.
Share with us your understanding of the doctrine of separation of powers.
Okay, the doctrine of separation of powers is a constitutional doctrine of our law, and it dictates that or rather it is proclaimed in our constitution that there shall be a doctrine of separation of powers, that it would be the legislature, the executive, as well as the judiciary. And this is to prevent one body having an autonomy on the different functions. So the legislature would be the lawmaking body, the executive would be the body that executes the laws, and the judiciary would be the one that sits and deliberates on legal disputes.
Thank you, DCJ.
Thanks, Commissioner. Deputy Minister?
Thanks. Good afternoon, Ms. Mthimkulu.
Good afternoon, Commissioner or Deputy.
Yeah. What you did a Master of Laws in at University of New Hampshire. What was it in?
It was in intellectual property.
Intellectual property. Okay. And on your questionnaire, there's a question: what proportion of your litigation work has been in the field of criminal law? And you said 90%. Was that when you were in practice, or is that your work in the district and regional courts?
Both in practice as well as in the district and regional courts. I think if you look at my CV, I worked or served my articles with the Legal Aid Board, and the major or the majority of work or the bulk of the work in the Legal Aid Board was to represent indigent accused persons in the criminal courts. So, and when I was in the district court, I was in both the criminal and the civil courts, as well as in the regional courts.
You've sat on civil matters in the regional court.
I actually sit on civil matters in the regional court as we speak. The majority of civil work in the regional court in Soweto is actually done by me. I sit in the civil courts in Soweto, in Protea Magistrates Court.
So since you came back as a regional magistrate, which was 4 years ago, what percentage of your time has been in the regional civil or the regional court as a civil court?
I actually do civil work every day. We have a unique setup in Protea. Initially, when I had started, I was the only one that dealt with civil work in Protea, and I would do divorces if there was a trial, or the motion court roll on a Friday. But when our civil started picking up, and a lot of matters were referred from Johannesburg Magistrates Court to Protea Magistrates Court. We found that we had a lot of matters that came from Johannesburg, and I was asked to do these matters or deal with these matters on a daily basis. So on a daily basis, I would sit with both the criminal role as well as the civil role.
Okay, thanks very much.
JP
CJ?
Mlambo?
CJ, I wanted to make a follow-up earlier about Thohoyandou. When were you shortlisted? When were you told that you are shortlisted?
Around, I would have to think hard about it.
Somewhere in
In
January.
February.
The shortlisting happened in January, maybe perhaps you were informed early February, like first week of February or so. What is the distance? Because seated here, we've got Jolas from Eastern Cape. They may not have an idea like you, what is Thohoyandou? So the distance between Polokwane and Thohoyandou, how many minutes or hours do you drive to Thohoyandou from Polokwane?
I stand corrected, Commissioner Malema, but I think it would be about 3 hours.
No, it's not 3 hours. It's less than that. So let's say it's 3 hours. You get told in February that you are shortlisted for Thohoyandou. For what it takes, you don't spend some hours with all this business. Because you can't say to me from January until now, you have never been to a social gathering or anything of that sort. Here is an area of interest. You don't allocate some few hours to go and check what is this place to show interest. So that indeed, when you come here, you are like, I'm very comfortable with the place. I'm not just going there for the sake of getting into this thing. The next interviews, I'm back here applying to go to a different place. Just an allocation of some few hours to go to Thohoyandou in and out, and then say to us, I'm comfortable with what you are giving me, because we are going to give you something you don't know.
Commissioner Malema, I think the fault is on my part, but when I was told I'm shortlisted, I was already acting in the Gauteng High Court and my transition from criminal to civil for the Limpopo division came as a bit of a shock in terms of the amount of work that I needed to do. I was allocated a lot of opposed motions. I had a lot of appeals that I had to preside over with very thick bundles, and I spent most of my weekends buried in those files, as it were. So it's not like I did not go to Thohoyandou because I was attending some social gathering, but it was just I needed to familiarize myself with the matters that I was allocated in the Limpopo division of the High Court and be well acquitted by the time I get there.
On a lighter note, DCJ, every election in South Africa, I make sure to make a tenant union building myself, because that's where I'm going.
JP Mlambo? Just for that, you will not get a turn to ask questions again.
DCJ,
Thank you very much,
I think there'll be
DCJ.
many of those turns.
Good afternoon, good afternoon, Ms. Mthimkulu.
Good afternoon, JP Mlambo.
Just two questions. One relates to the reserve judgment you reflected on the 28th of September. Has it been handed down, and if so, when?
The judgment of that is on there was handed down on the 13th of December 2021.
This state versus Magengenene.
Oh, sorry, 2022, 13 December 2022, State versus Makengenene.
Thank you very much.
The matter, yes.
Now, the other matter you reflect as apartheid, I think just your probably deals with your philosophy as well as a judicial officer regarding access to justice. Is this the matter that you say has many counts and it remains apartheid?
That is correct, JP.
It's a Gauteng matter.
It is a Gauteng matter.
I have a number of these matters in Gauteng, and parties, especially the presiding judges, make a point of being tough on practitioners to make sure they open up time. What is preventing this matter from getting to finality?
JP, that matter we have set, and we have listened to evidence in that matter. The council are always there. I think when you were away in the Constitutional Court, we were also given a term and we ran with the matter. And witnesses were subpoenaed. We've listened to that matter or dealt with that matter. Each time it's been set down. So it's not as if there has been any truant from either the state advocate or the defense counsel in that matter. It's just the complexity of the matter, and some of the witnesses in that matter, JP, are coming from KZN, and each time witnesses subpoenaed or called to come and testify, we sit a full day in the matter.
Well, I wasn't suggesting truancy on anyone.
No, I'm just saying, JP, that we have dealt with it. If you can see the files in the matter, you will see the progress we have done in the matter.
Yeah. Is this the matter where you say the accused are on bail?
No. All 5 accused are in custody because some of them have been convicted in other courts and are serving sentences.
Okay. I think from an access point of view, just my comment, nothing prevents yourself from getting long-term commitments from counsel and state advocates in the matter and get given time, 2 terms at a stretch, to make sure that this matter finishes. Thank you, DCJ.
I will remember that, JP.
Prof?
Thank you very much, DCJ. Good afternoon, Magistrate.
Good afternoon, Commissioner.
I have a question for you in relation to criminal law generally. But I will start by saying there are concepts in law which, from time to time, we see that they become even more difficult to explain, like your good cause shown, and the one that I'm going to ask you about now, exceptional circumstances. And my question to you is, when one looks at Schedule 6 of the Criminal Procedure Act, that deals with bail applications in terms of that section, and it requires this particular requirement, exceptional circumstances. In your view, what constitutes exceptional circumstances? Because it appears that this is something that is used either to grant or to deny bail without really explaining. No, the interest of justice, there are no exceptional circumstances, bail is denied. So how should this particular concept be understood so that we can get some sense of consistency in the manner in which bail applications are dealt with in terms of Schedule 6?
Thank you, Commissioner, for that question. Exceptional circumstances has not been defined, but I would suppose that when we deal with phrases or, like in this instance, exceptional circumstances, phrases that have not been defined, the starting point would be to give a grammatical meaning to to the words and try and see if there's anything that's exceptional. I've heard people, well, when they address you, they would be like, if the applicant in a bail application does not prove or does not show that if bail is not granted or bail is granted, the sky will fall, then there's no exceptional circumstances. But it would be to like give a grammatical meaning to the words that are before us, or to the phrases, I suppose. But that having been said, exceptional circumstances have not been defined, and you would also maybe look at the merits or the circumstances that you are dealing with at that point in time to determine whether there is exceptional circumstances or not.
All right. My final question is in relation to the Section 302 automatic reviews that normally come from particularly district courts, and I understand that perhaps maybe you are at the regional court. When you look at some of the decisions all across the divisions of the High Court in different provinces, most of the judges are complaining about the quality of the responses when queries are made to the magistrates. But not only that, the delays that are actually occasioned by such replies. And they delay, but they are inadequate when they are actually provided to the judges. What causes this? Because sometimes you find that in these reviews, the accused persons are actually in prison. What causes these delays, and how can this issue be addressed so that we can ensure that justice prevails?
I think from where I come from, these delays are usually caused by the support staff, because say in the appeals office, for instance, or the clerks that have to, when they receive these like application for automatic review or whatever the case may be, if they're not well trained and do not know the time periods or the urgency that they have to act on when these land on their desks, it becomes a problem. So if the court support staff or the clerks that have to assist the magistrates in, say, giving reasons, for instance, are not trained, we will never see the light of day. It would always be a problem with the delays.
So we are going to blame them also on the quality of the replies. But anyway, I will leave it there. I will leave it there, DCJ.
I'm sorry, I didn't get the quality of the reply. I think also maybe at SAJE, those are things that should be taught. Because I find when we go to these trainings, there's things that they don't give as much training on, because they maybe assume that everybody knows how to handle these.
It's fine, I will leave it there, DCJ.
Thank you.
Commissioner Dodov?
Thank you once more, Deputy CJ. Ms. Mthimkulu, I can see that you have a lot of educational qualifications. Now, I want to draw you to these qualifications. 2009, you completed a higher diploma in tax law.
That is correct.
2010, diploma in international taxation. And 2014, you went to the US and studied a master's in intellectual property law. And looking at what you were doing as an attorney, you spent 90% of your time on criminal law. Can I assume that all of these are in vain? Because where you are applying to, there are no areas of tax law like they are where you are moving from. In Johannesburg, in Gauteng, that is where tax issues are. That is where international tax issues are. That is where intellectual property issues are. And you want to go to Thohoyandou. What exactly drives you to want to go to Thohoyandou and live an area where you can best apply and proliferate what you have learned at different institutions of higher learning?
Thank you for that question, Commissioner. I think when I went to varsity and got these qualifications, my plan, or rather my thinking was that one day I would be able to can use these qualifications. But when it comes to issues of where one applies and where one gets shortlisted, unfortunately, it's not something that I have a say on. I can apply to a division maybe that wherein I can use these qualifications, but if I do not get shortlisted in that division, it's not something that can be blamed on me. When I pursued a higher diploma in tax law and a higher diploma in international tax law and did a master's in IP law, I wanted to have these qualifications so that when one day I present myself before the JSC, I can say, this is what I've done.
Yes, but you are not practicing them. And I put it to you that where you want to go to, these things are quite limited. And on that score, have you made a research about the court where you want to go to? What kind of cases,
Yes,
the nature of cases, and what? Because I would argue that this is very, very lean.
I have made my research. Unfortunately, that's where I am shortlisted.
Or you just want to be the judge more than any other thing else because you applied to be a judge and your application was considered and that you are shortlisted to Limpopo. Are you saying to this commission, all you want to do is to be knighted as a judge?
Not necessarily, sir. That's a incorrect
That's the impression
assumption.
that I'm getting from you, that you applied and you got shortlisted. And in this particular instance, you are shortlisted to Limpopo in Thohoyandou. And I'm saying, I'm looking at this and I know the area. That area service Madumbisa, Musina, Makado, Thohoyandou, and all of those. Those are villages. I'm sitting here thinking, I don't think of any intellectual property matter that can come before to the attention of a lawyer or a court in that the only, if there would be a struggle, it will be about black leopards more than anything else.
I hear you, sir, but you may be surprised that there is maybe one IP matter and I'm better suited to can deal with it in that
right.
area.
Okay, no, it's okay. I'll deliberate. Thank you very much.
Thanks. Just a quick follow-up from Commissioner Dovu's question. If you got appointed, how long would you plan to stay at Thohoyandou for? Or when would you start applying, when would you start applying for other posts? But can you give us a commitment if you're appointed, I'll be here for 5 years before I apply again, or you're not in a position to do so?
I'm not in a position to do so because I do not want to be, I do not want to limit myself. I might want to apply, if I am recommended and I feel I'm ready to apply to the SCA, I do not want to be told, but you said you want to stay in Thohoyandou for 10 years or 15 or 20 for that matter. Because there's other options that might come up should I be recommended.
Okay, but I think the concern from many commissioners is, and I think it was what Commissioner Malema had said, that you would get, if you get appointed, will the next round of JSC interviews see you applying for other High Court posts? That's a concern. So I'm giving you the opportunity to persuade us otherwise.
I will stay in Thohoyandou. As long as it's feasible, and I will stay in Thohoyandou.
But you don't know if it's feasible because you've never been there.
Can I just make a short follow-up to Commissioner Dodovou's question? Mr. Dodovou says that you will not get IP law in Thohoyandou. You may not get it, but you say, well, perhaps you may. But I want to ask you about something you may actually get in Thohoyandou, which is customary law. So if you have a dispute on a rule of custom, Party A says the rule is X, Party B says the rule is Y. How do you approach the resolution of that rule, and what are the leading authorities from the Constitutional Court and Supreme Court of Appeal that will guide you?
I do not have an answer for you, Advocate Ngwaitobi.
Thank you, Deputy Chief Justice.
DCJ, if I may just follow up with the Minister and Commissioner Dodovou's question. Good afternoon, Ms. Mthimkulu.
Good afternoon, Commissioner Pillay.
I have a separate question that I'll ask you in due course, but I was very concerned by an answer that you gave in response to a question by Commissioner Dodovou. And I'm really hoping that I heard you incorrectly. So I need to, in fairness to you, I need to give you an opportunity to deal with it. I thought that you said that, unfortunately, that's where I was shortlisted, in reference to the Thohoyandou court. It's a very concerning statement, and I really would like to give you an opportunity to address that.
It might have come out wrong, Commissioner Pillay. Rather, fortunately, that is where I was shortlisted, because I had applied to the Limpopo Division of the High Court, that is Polokwane as well as Thohoyandou. I put in that application. And I also applied in the Northwest, and I was shortlisted in Thohoyandou. I applied for Thohoyandou. So it's fortunate, it's just probably came out incorrectly.
Thank you, DCJ. Is it my turn? Thank you. I just have one question, and the question is really designed to probe your judicial philosophy. So can I ask you, and I really want to ask the question in relation to your Muzwakali judgment. I think it's the last judgment included in the pack. Do you recall that judgment?
Yes, I do.
It's an appellant who appeared before you, and he was appealing against both conviction and sentence. And he was convicted of raping a 6-year-old little girl. Do you recall the matter?
Yes, I do.
And you considered the appeal against conviction, and you confirmed the conviction. In other words, you found that he had raped the little girl.
That is correct.
Then when it comes to sentence, you had to consider whether or not there were substantial and compelling reasons to depart. Do you remember that?
That is correct.
And I want to read to you, because I don't want to do you a disservice, I want to read to you what you say about substantial and compelling circumstances. You refer to the evidence of the doctor, and you say, the doctor further elaborated in his evidence that the blunt object that caused the attempted penetration could have been anything ranging from a penis, a finger, or a foreign object. He further conceded that if a lot of force was used, the object was pushed in very hard. The severity or extent of the injuries would be apparent. However, if the object was inserted gently, the result is that one would get less severe laceration. Then you say the conclusion of the doctor is that the degree or extent of the injuries suffered are less severe compared to a person who was fully penetrated. And you say, I therefore regard the findings of the doctor as substantial and compelling circumstances. justifying a deviation from the sentence imposed by the magistrate. Now, do you still stand by this finding that if you have penetration that is gentle, or if you have penetration that is not full, and the victim, as in this case, is a 6-year-old little girl, that you consider that in itself to be substantial and compelling reasons to depart from the prescribed minimum sentence?
Okay, I have had a long thought about this judgment, and you correctly point out it was an appeal judgment. I have to disclose that in this appeal, it was a full bench appeal. I had written 2 judgments, but the senior judge that I sat with was of the view that that because this is what the doctor's findings were, that the initial judgment that I had written would not stand, and so I was conflicted and probably swayed by the senior judge.
So, Mr. Mthimkulu, I really don't want to cross-examine you, but I'm afraid your answer makes the whole thing worse. Because it now seems that you don't agree with the judgment that you included in the pack. And secondly, that the judgment doesn't reflect your honest views on the matter.
I think it does reflect my views on the matter, but we were a bit, there was a bit of a power struggle as to the conclusion that we got to.
Follow-up, sir.
My own follow-up first. Are you suggesting that you allow the senior colleague to dictate their view on you?
I was swayed by the senior judge.
Were you persuaded
Persuaded, yes.
that he or she was right?
Yes, because it had been said, or rather the doctor's findings were not certain as to what had caused the injury on the complainant. It could have been either a finger, a penis, or a blunt object. There was no, it wasn't decisive.
So you were persuaded that the senior colleague is correct?
That is
in their
correct.
view? Okay.
Now, DCJ, on your point, so just a quick one. We are now abandoning the point you raised that there was a power struggle. Because persuading and power struggle are 2 different things. You must choose your struggle. Which one is your answer?
I was swayed, Commissioner Malema.
So the power struggle is off now?
Yes.
Okay.
No, I'm covered. I'm fine.
Thank you, DCJ. Good afternoon, Ma'am Mthimkulu.
Good afternoon, Commissioner.
Just one clarification question from myself that stems from the answer that you gave when you responded to the question on the separation of powers. Did I hear you correctly to say that in the Constitution there is a clause that says there shall be 3 arms of government? And 2, isn't it correct that in the Constitution there is no clause specifically that says there shall be 3 arms of government, but rather what we have, you will have chapter 4 that talks to the working of Parliament,
and that in Chapter 5 of the Constitution, you will have the working of the executive, and in Chapter 8, you'll have a chapter that specifically talks to the work of the judiciary. Is that not your understanding? Thank you, DCJ.
I think there is a proclamation. I might not have the Constitution before me, but there is in the Constitution a proclamation that there shall be 3 arms of the government, or 3 arms being the legislature, the executive, and the judiciary.
Thank you, Mthimkulu. Thank you, DCJ.
Thank you, Deputy CJ. Good day, Ms. Mthimkulu.
Good day, Commissioner.
You know, mine is quite different. I just wanted, you spoke about training, so that some of the training, it doesn't equip one with some of the, the tools of being able to do certain things. My question to you is it's not a question, I just want to hear your opinion. Do you think that the regulator or the Bar Council, we should introduce continuous legal training, even if we have qualified as an attorney or an advocate? Because for me, I think we seem to think once people have qualified, they can swim on their own. Do you think so?
I think not only in the Bar Council, throughout, be it in the judiciary, the magistracy, attorneys, advocates, training should be something that we strive. There should be continuous training. It doesn't matter where you sit. It is important just for us to be sure that we are on the same page when we deal with the administration of justice.
Just a follow-up, do you think, what I'm trying to find out is that should we compel you to do continuous legal training and for like other professions, or do we leave it to the discretion of the candidate that, for instance, judgment writing,
Can you please repeat your question, ma'am?
I'm just saying, I'm thinking, do we think we should compel qualified attorneys and advocates to undergo continuous legal training on other matters that they haven't learned? Or we leave it to their discretion to do it?
It is a tricky one, but I think maybe compelling would be the way to go, Commissioner.
I'm not entirely sure what's going on, but it does appear that our recording operations are still okay. Can I just find out if the colleagues on the virtual platform are still connected? Commissioner Bernard, are you there? Commissioner Breitenbach? We may have lost them. Can someone tell us what's going on? Who's responsible for? Okay. Yeah, it's still low. Okay, well, I'm told it's probably load shedding, and it usually takes about 5 minutes for the generator to switch to kick in. All right, we have a report. Our commissioners on the virtual platform are connected, but they're trying to get the sound back. So we should just wait a little bit. We're almost done, colleagues.
Thank you, TCJ. Good afternoon, Acting Justice.
Good afternoon, Commissioner.
Acting Justice, I would be unfair to you if I don't ask you this question. In fact, I want a comment. It flows directly from the debate we had with Commissioner Pillay and the DCJ about the judgment. First, do you say you wrote two judgments? One which says there were no exceptional circumstances, and then one says there were compelling reasons that were been established. What is it when you say there were two judgments?
Well, the initial judgment that I had wrote, we had to deliberate on, and I was swayed by the senior judge, and we came to the conclusion that we came to in the judgment that I penned, and the conclusion that I came to. So it wasn't two separate judgments.
My problem is this, I just want to put that, is that to me, your answers you give to this very important question, that you are not an independent person. If you think you are, you lack backbone, you lack backbone, you know, and those are qualities that go for a judge. Because I'm saying this, I want you to comment, because you have accepted, once you are persuaded, you have accepted, it becomes your judgment. Now when Commissioner Pillay is asking you about that, do you stand by this finding? You say, no, I'm running away. It was what the senior judge was. It means as you sit there, you don't know what was your judgment.
It may not have come out correctly, Commissioner Notiesi. What I was intimating at was that I was swayed by the senior judge upon deliberation, and I took the advice that was given to me by the senior judge.
Thank you.
It may not have come out correctly.
Thank you, DCJ.
Well, if it helps, acting judge, JP Mlambo and I were just reminding each other just now how a similar event occurred to us years back when we were still junior at the SCA in the case of Shilubana, where we were persuaded, but we were persuaded. We were persuaded by senior colleagues much against what we thought was a very stern position, and that judgment ended up being overturned in the Constitutional Court, and our original view being, being the judgment of the day. So it does happen to the best of us. Don't feel bad.
Thank you, DCJ.
DCJ, just a follow-up.
Yes, Commissioner Konish.
Good afternoon, Judge.
Um,
Acting Judge.
Good afternoon, Commissioner.
But when you had a conversation with Acting Judge President, you said you don't like to wreck the boat. And it was when she was complimenting you that everybody likes you. you said you would be surprised if there was no one who did not, because it is in your nature, you just don't like to wreck the boat. Is that not consistent with what you are just saying now?
It's not. What I meant is I'm collegial when I work with people. That's all that I was intimating at. You know, I respect everybody that I work with, and that's in my nature. If it came out incorrectly, I apologize, but I'm just collegial with colleagues in general.
No, it's not something bad. I think it's something good, but I'm linking it with what Commissioner Chase has just been raising now. Oh, I'm saying it's not something bad, but I'm linking it with what Commissioner Chase has been raising it now, the ease with which you were swayed.
I take that's how it's understood.
Thank you, TCJ.
Any more questions? Oh, there is a follow-up that's been idling for a while from JP Mlambo.
Thank you very much, DCJ. Ms. Mthimkulu, I just want to go back to that question when you are asked to say you only applied to Thohoyandou. I want to understand your answer. You say you applied to Thohoyandou and Polokwane.
Yes, and
Northwest.
Northwest, yes.
And Northwest.
Yes.
Okay. I just wanted to confirm that. And but this year was not the first time you applied, am I correct?
That is correct, JP.
In 2021, you also applied to 2 divisions.
How many divisions?
2 divisions.
Yes, that's
Is it
correct.
2 or more?
It was 2.
Thank you. Thank you, DCJ.
Any questions from the virtual platform? Mr. Barnard?
DCJ, but thank you for the opportunity.
All right. Ms. Mthimkulu, this is the end of your interview. Thank you for making yourself available for this interview.
Thank you, the DCJ, for the opportunity, and thank you to the JSC for giving me this opportunity to present myself to the JSC.
Okay, you're excused. Go well.
Thank you, and have a good day.
Thank you.